This video is presented by the Office of Ohio Attorney General Mike DeWine and was made possible in part by a grant from the Ohio State Bar Foundation. The views expressed herein do not necessarily represent those of the Ohio State Bar Foundation. Please be aware that Ohio's Public Records and Open Meetings Acts are both self-help laws which the Attorney General's Office has no authority to enforce. The content presented in this video is for informational purposes only. For specific legal advice, please contact your legal counsel. The Ohio Public Records Act ensures that the records of public offices in Ohio are available to any person who requests them. To examine the records of a public office, the first step is to make a request for the public records you would like to view. This video will cover your rights and also your obligations under the Ohio Public Records Act as a public records requester. It will also provide some helpful information and resources to make sure you receive the records you are looking for as quickly as possible. There are a few points to keep in mind when composing your public records request. First, a proper public records request is one that asks for records that actually exist at the time that the request is made. This means, for example, that a public office is not obligated to provide records that have been properly destroyed after their retention period has expired. This also means that a public office does not have to provide you with information that does not already exist in a record. For example, if you ask a public office for a list of court cases pending against it, but the office does not already keep a list containing that information, the public office does not have to create such a list in order to respond to your request. This makes the Ohio Public Records Act a bit different from the Federal Sunshine Law, the Freedom of Information Act, or FOIA. The Freedom of Information Act is a law that gives you the right to access information from the federal government. The Ohio Public Records Act applies to Ohio public offices and requires you to make a request for records as opposed to information. Finally, a public office does not have to provide you with records that have not yet been created, even if they will someday be created. Second, the public office needs to be able to understand what sort of records you are looking for. To this end, the Ohio Supreme Court has said that a request must be made with reasonable clarity. That way, the public office can identify and locate any records it has that are responsive to your request. The public office must also be able to identify the records you're looking for based on the way the office ordinarily maintains and accesses its records. For example, if your request is too ambiguous or too vague, a public office may not be able to figure out what records you are looking for. Also, if your request asks for a very large volume of records, a court may find it to be overly broad and decide that the public office does not have to respond. An example of an overly broad request might be all emails created by the Attorney General's Office since 2006. This request could potentially involve hundreds of thousands, if not millions, of documents, and is not the way the Attorney General's Office organizes and keeps its emails. The Attorney General's Office generally keeps its email correspondence organized according to subject matter or case file. So, a request like all correspondence, including email maintained in the file for case Smith v. Jones, is a more narrow request and corresponds to the way that the Attorney General's Office organizes its email records. Public offices are required to create retention schedules for all of the records they create. These retention schedules are an excellent resource to help you formulate your public records request because they can give you information about how an office organizes and maintains its records. Retention schedules for state agencies can be found online. You might need to inquire with local agencies to review their retention schedules. In short, your public records request must be reasonably clear so that the public office can identify and locate any records that respond to your request. There is often a practical benefit to composing specific, narrowly tailored requests. It allows the public office to more quickly and efficiently find the records you wish to see. This helps both you and the public office. Next, let's review some of the rights you have as a public records requester. First, your identity. Anyone can make a public records request. A citizen of another state, a non-U.S. citizen, a corporation, a minor, another government entity, etc. Also, you do not have to disclose your identity to make a public records request. You may make a request completely anonymously. Second, your request. You do not have to make a request in writing. You may make a request verbally, in person, over the phone, by email, by fax, or by any other method of communication. You also do not have to use magic words or refer to the public records law, as long as the person you are communicating with can determine that you are making a public records request. You have made a valid public records request under the law. Third, how you get the records. You have two choices when making a public records request. You can either receive the records by copies, or you can choose to come into the public office to view the records in person. If you choose to receive copies, you have several options. 1, you can choose to receive paper copies. 2, you can choose to receive copies in the form in which the public office keeps them. If the office keeps the records on paper, for example, then you would receive the copies on paper. Third, you can choose to receive the copies in any other form that the public office determines is reasonably available. For example, you might request to receive an electronic version of paper documents if the office determines that this is reasonably available. The public office can charge you the actual cost of making the copies and sending them to you. Be aware that this cost cannot include employee time spent gathering the documents and making the copies. Rather, the charges can only include the actual costs of copying and mailing. That is, the paper, ink, toner, etc. used to make the copies, and the actual cost of shipping the records. You may also choose to pick up the records at the public office. The office can also require payment up front before it releases the copies to you. Finally, timing. If you choose copies, the public office has a reasonable amount of time to provide them. Please note that you do not have the right to give the public office a deadline for providing the copies. The office is allowed time to locate the records, review them, make any copies or redactions, and consult with their legal counsel, all while attending to their regular job duties. Depending on the size and complexity of a request, the reasonable time to complete all of these tasks may take days, weeks, or even months. If you choose to view the records in person, the public office must provide them promptly. Be aware that prompt also includes the time it takes to locate the records, review them, make any copies or redactions, and consult with legal counsel. Even if you arrive in person to make a request to view public records, the office is allowed to take the time to complete all these tasks. You might not be able to view the files you request on the same day. You will have to come into the office during regular business hours to view records. The public office does not have to provide special hours so you can view documents at your convenience. Also, if you view records in person, the public office cannot charge you any fees. A good place to start for information about charges for copies and viewing hours is the office's public records policy. Every public office in Ohio is required to have a policy and post it in their office. Many offices also post their policy online. You can find the Attorney General's policy on our website. The public records policy will give you information about how that office handles public records requests. We've been discussing your rights and obligations under the law, but here are a few practical pointers to help smooth the process. Find the right public office. You may want to call around first so you don't waste time corresponding with an office that doesn't keep the records you want. Prepare. Review your rights and responsibilities under the law. The Attorney General's office provides many helpful resources. Be as specific as possible when making your request. The more specific and narrow your request, the less time it should take for the office to respond. Use the public office's website and retention schedules to help you get a better sense about how to formulate your request. Ask for the records you really want to see. You can always make an additional request later if necessary. Finally, be willing to negotiate and revise your request. It may help to share why you want the records or to ask the office, what would you recommend? Build a good relationship with the public office. A cordial relationship helps the process run smoothly from both sides. Be clear about how you would like to correspond with the public office. Provide your correct contact information and follow up reasonably if the response seems delayed. Let the public office know if you want to be notified of any costs for copies. Although you are not required to, make your request and follow-up communication in writing. This helps to reduce any misunderstanding later about exactly what you asked for. For more information on this topic, please consult the Attorney General's Sunshine Laws Manual, which can be found on the Attorney General's website. We hope this video was helpful to you. Please use the provided link to complete a brief survey regarding this training. We appreciate your feedback.